the police is raising issue on the NECO matter. The court has clarified the WAEC issue, which ab initio was the case that some guys went to court trying to stop the senator from contesting in this election. Could that case, if, for example, the police had gone ahead and arraigned him, could there be any possibility of stopping the senator from contesting on Saturday?
No, an arraignment on his own will not stop him from contesting an election, as I've said. The police is not a court. The police is not an election tribunal. So to stop him, you will have a pronouncement of the court disqualifying him based on the presentation of a forged certificate, allegedly. Now,
could they have also gotten an injunction pending a pronouncement of court?
In a criminal trial process, you won't talk about an injunction. So the police will merely prefer a charge, and the charge will run independently of what the election conduct is all about. So the court, the trial court in a typical criminal matter, would pretend as if it's not aware of any election matter. It's just facing the criminal trial.
As presented to him.
Exactly. But in the other case, co-contestant, I believe, in the PDP, or some persons who felt that he shouldn't be the candidate of their party, filed an action against him, saying that he should be disqualified because, and now the result, his result, had been stated by WAEC, claiming that he has F9 in English language, right? And so the requirement of the Constitution for qualification in terms of academic requirement is that a candidate, even for the office of the presidency, if he has up to, that's the language of the law.
That's up to Section 177 D.
Exactly.
Says that if he has been educated up to at least school certificate level or its equivalent. So he doesn't have to pass it.
It doesn't up to that's the language is loose, is just basic.
Whether he had F9 or through, doesn't matter.
It doesn't matter. You've had up to school certificate.
Is there a problem with that section of the law?
I think there's
that the governor of a state should just have and sit for an examination, not necessarily passing it.
I think there's a problem with it, and the problem I have with it is that it's ridiculous. It should just be removed. Let the electorate decide who should govern them. I want to believe that the electorate will want a smart person.
Shouldn't there be a minimum qualification higher than a school certificate?
Trust the electorate to discern, to know what to do. Look, even in rural Nigeria in the past, secondary school leavers were treated like kings. Children, women in the house will put the bucket in the bedroom for that person, special person, to have his bathing, special food will be prepared for him and all. That's how education was recognized. So people will know. People will not want somebody who's not educated to come and govern them. I'm serious.
Well, isn't that going to be a major problem? Because at the end of the day, you just find people who cannot even read their own speech becoming leaders in the land and who cannot even address major issues. Education has gone beyond all that, isn't it?
If that person is the person the plebeians feel should be their leader, so be it. I'm just saying, so be it. You just remove that, because the requirement is so basic, so remove it. I won't advocate that you should put a university degree there. Don't put those things there.
But let's look at the case of Senator Adeleke. As it stands right now, the intervention of the president has perhaps given him some kind of soft landing. But what could be a possibility? Should he win this election, for example, could it be an albatross on him, or a technical trap for him, a legal technical trap?
What's the technical trap here?
When there's a charge of criminal nature.
Except is presented an additional paper. Because obviously, this is what I think. This is my surmise. Circumstances and fate threw up Senator Adeleke, who is adroit in dancing. Unfortunately, his brother died. Spy never knew that he would be gunning for a public office. So suddenly he found himself, you know, in the eye of the storm. He ran for a public office. He clinched it. And so realizing that his certificate was not, by his own assessment, didn't measure up. So he is interested in improving himself, and perhaps that's how the other NECO thing came. If he then used that, submitted that in his form as part of his documents, that could be a trap. But if he didn't, that allegation would just be there. If he's elected, for example, and is clothed with immunity, that means you can't get to prosecute him until he drops the toga of that immunity. If he doesn't win the election, and the police haven't stayed, you know, in accordance with the directive of the president, the police can then come back to it if this is not politically motivated. Because at that point, they say, what's the point? He's lost the election anyway. But if it is not politically motivated, if the objective is criminal law enforcement, the police can always come back to it and say that you have your day in court.
It's an interesting scenario playing out. Perhaps some kind of precedence that is given for our law shapers and farmers to rethink some of these clauses in the law, maybe in the future.
A lot has to be rethought.
Yeah. But I must really thank you. A lot of legal understanding that is necessary. I've tried to bring every law necessary here so that we can get perspective. Well, many thanks to you, Mr. G.T. Ogunye, for your time on the program.
You are Shani's lawyer.
On
politics today.
On politics today. Thank you so much. That's Mr. G.T. Ogunye, a lawyer and a friend of the house. That's our show for tonight, everyone. Many thanks for being part of it. I'm Sean Wakimbaloye. Bye-bye.